Hello, loved ones. How
Hello,
are
everybody.
you?
Hi there.
Welcome to Dï5 Lïve. Please, if you do not have your selves on mute, please do so, as we need to be able to, first of all, hear what we're going to be saying, and we would also like to be able to see you. There are no black screens that are allowed. That does not mean that a screen can look up at the ceiling either. We want to see faces. We want to know who we are talking to. We want to know who is interested in all of this information. So if you decide to put your screen on black, we have queens that will be coming and removing you. So please make sure if you're going to participate, you participate. Wonderful. All right. So like I said, welcome to Dï5 Lïve. We're excited about doing this. I'm going to tell you actually how this came about. We actually were about to go on to our strategic council last night. And as I was getting ready, Darren comes up and tells me he wants to start doing some live classes. I said, that's fantastic. Let's talk to Kim afterwards and we'll figure out how to do this. We go online next, 10 minutes later, he is launching this idea. So that's how quickly it happened. We're excited to do this, but let's talk first of all, and Darren, please shed some light on why you are wanting to do this and why it was so important to do it so quickly.
As I was mentioning last night in our other meeting, as most of you know, the amount of effort it takes to work with these documents and do all the research, this, that, and the other. I spend the better part of 10 hours a day minimum, almost every day, at the computer working on this stuff. So I'm thinking, why wouldn't I just have the camera on while I'm sitting here doing this? I can interact with anybody, everybody at any time within the window of opportunity here to be more interactive, to deal directly with pertinent information, materials that we're dealing with. This way, we can have an ongoing criteria that just evolves as we go. As I had just mentioned earlier, there is a need for this. Why wouldn't I capitalize on it? Why wouldn't I take advantage of it? Again, I can. It's just as simple for me to hit the camera and away we go. I know watching videos, like when we pre-record them and post them for everybody to watch, that's one thing. But I think that this interactive live stream is actually going to be beneficial in a number of ways. It's going to give the audience and everybody who's interested in this truth movement and all this stuff we're doing, it'll give you access every day to what we're doing. And if for some reason, you can't quite make this time frame, don't worry. I'm going to start bouncing this time frame around. I know we have a lot of loved ones all over the world, and it's not quite fair for me to be not considering their circumstances as I do this. So again, for people in Australia, New Zealand, and those next to the woods, I don't mind doing these things either earlier in the morning for us or later in the evening, whichever. That will come though.
Excellent. Annette Jackson, if we don't see your face, you are going to be removed. That goes for Tina. That goes for David. We are very strict on this. And Darren was the one who was wanting to see faces. So again, there is going to be no leniency on this. We see your face or you're removed. Why was that important to you, Darren?
Well, number one, I can establish better connections with the facial thing and knowing that you're actually here versus the black screens. At the end of the day, we're here to share information, and if I'm only dealing with a two-dimensional image, you're only going to get two parts of the message. Almost is the way this feels for me. I can't quite connect quite the way I want to. So we're just going to keep trucking with this motto. And if it turns out, this is not a fashion show, don't worry about it. These meetings will not be posted. These will not be shared. These are going to go into our archives, and that's it. The way that this is going to get structured, Jody's going to mention here in a moment. I don't even really want to be sharing a lot of the documents and the things I'm doing. When I share my screen, I would hope that you'd be able to just take a screenshot of it or take your phone and give it a snap and then go back and start building these documents. And then once you have your own working version, and again, I could share it, but you know what? So much is learned or lost when you just don't jump on and just quickly punch these out for yourselves. Because as you're looking at these words, as you're displacing them, there's an incredible connection that you're developing just by doing that. So these two here, I let the cat out of the bag. I referenced the other day the one document. I'm actually bringing two to the table tonight. So I want to spend about half an hour on the one and about half an hour on the other one. And I know the clock is ticking here on me, so I got to kind of let this stuff rip as we go. But again, number two, don't feel panicked about you having to get all the information rammed into this right now. I want to set this as a thing where I don't mind doing this for a week or two or three to see how this is well received, and then we'll go from there.
So let's get a few housekeeping questions off the table right away. So first of all, you know why we are doing this. Second of all, we are going to try and address as many questions as possible. Here's the thing. The majority of your cases have the same remedy. So what ends up happening is we do these kinds of things with our loved ones, and they get into their long-winded story about their cases, and the stories are irrelevant. We just need to know Cole's notes, what you're dealing with, and it's the same remedy every time. So that's why there's no point in putting one of you on to tell us your court case, because we want you to put it into the chat. Keep it short, keep it simple. What are you dealing with? What are you up against?
The time frame.
And the time frame. And then we're going to start compiling cases that are the same throughout the chat, and then Darren will be addressing it for you. Okay, so that's the first thing that you need to know, is that if you want your questions answered, you need to put it in the chat. Our queens are going to be monitoring it. We're going to, again, put the questions together. We can address more concerns, utilize this man's time better. If you guys work with us, we compile things, and then he addresses them in groups. And this man can rattle off remedy like you wouldn't believe. So have your pens ready. It's about who shows up, who shows diligence in all of this. We will also, and this is another housekeeping, we will not be emailing or putting any of our forms up, period. If you're here, you can take snapshots. We don't care. Take whatever information we put up on here and use it. We're encouraging. That's why Darren is doing this, to start getting more of our loved ones through the system, putting this information out there, getting this energy flowing so that they know we're coming, because it does work. Okay, so just know, if you're like, oh, email me that, do your own work, do your own diligence. We are handing this to you on a silver platter. Take it. I'm not going to put it into your pocket as well, and nor will Darren. So with that, we are also going to touch on a little part that is very, very important. Kindness and respect is going to be absolutely expected. Darren, do you want to touch on that, please?
You know what? The distractions of people coming with, again, I actually used this as an example last night when I spoke in another meeting. Someone can ask me, Darren, what gives you the right to do and say what you do? I have no problem spending 20 minutes answering that. But when they phrase the question with that, that condescending, negative
sense of entitlement,
that shitty attitude attached to it, it just kind of turns me off, and I kind of just don't want to deal with that energy. So come with a loving, respectful position, and I will do everything I can in my power to help people. I've done that for years, despite the stones and the daggers and all that. So I don't care about all that.
This man is never charged. Did any of you give us a penny? Did we ask for anything? No, he shows up willingly.
Except for, again, if people have in the past expressed the interest in booking me for the 1 hour or the 2 hours, we're not talking about that. We're talking about this type of communication where we're just trying to, lay as much substance out there and let you guys jump in teeth first and grab onto some of this. Because just quickly in a nutshell here again, we know how beneficial it is when you feel like you have done a significant portion of the work. You can connect to it, you can relate to it. It'll serve us all much better.
Kim, would you like to touch on that a little bit? As one of our, Kim is Divergence Chancellor. She is our direct downline. Everything goes through this woman. We also have Serena on here as well, one of our queens. But Kim, you and our other queens are doing equity classes. Can you talk to those loved ones very quickly as far as the importance of doing it themselves, please?
Yes. So you guys you'll see materials on here and we'll speak of it, but the importance of learning it and integrate. So when you go in front of a judge and when you write your paperwork, you have to feel and know what you're talking about. There's so much power in that. And that you can't have it from somebody else. You have to earn it and do it yourself. That is the most important. If I could tell you one thing about equity, that would be it. Go forth and learn everything yourself. There is power in that. We are here to reclaim what was ours. You must do the reclaiming. No one else can do it for you on your behalf. I cannot stress this enough. Know it, feel it, understand it. And if you can, go forth and teach it afterwards. But know it for yourself first.
Exactly. We are training you for court. if you're going to go down this road, you need to be prepared to stand in front of a judge and be able to use the proper language, to use the proper terminology, to be able to express yourself, because one wrong word and you're out.
Yeah, they'll cut us some slack, but yeah, for the most part, we have to be pretty dialed in. We have to be pretty on the money with what we're trying to tell these people. They want very concise information. They want very, dialed in claims, things of this nature. There's not a lot of wiggle room here, believe it or not. I mean, this is what we're going to come to do together as a group. I'm going to post what I've got going on, and if any of you have suggestions, I would not hesitate to entertain suggestions. This is a group thing. I mean, I've been doing this with other loved ones for years, but that doesn't mean one of you just stumbled upon something spectacular and has, wants to share it. And again, this is why the significance of having a program that airs, once a day. I think we can really start to stay on top of what we're trying to do here. And I see incredible value in it anyway, and I hope you do.
And our loved ones, are they allowed to record?
Yeah, you know what? I don't care if we record any of this. I'm not here to. The drama that you see us go through online is just that. It's entertainment. When it comes down to the meat and potatoes of the paperwork and getting us to the place of safety, where we're not subject to that enslavement, to me, at the end of the day, that's all that's important. And we're bringing everything we can to help people get there. So drama, if we want to have an episode on this program where we talk about drama and TV shows, maybe we'll talk about that one day. But for the next handful of days, let's just concentrate on this stuff. And this came about because yesterday or the day before, I had made some posts about a gentleman friend of mine who's experienced some very positive incidents or some experiences with the police in his area based on a couple of these letters that we're about to disclose right now. So again, we got to stick to what's important here. If the entertainment, is very exciting for you, yeah, follow that as well. But I have no problem kind of separating the two. Things are happening to us right now online and in the world around us for a reason. It's drawing attention to everything we're doing for a reason, and I'm fine with all of it.
Okay, so let's get into it. Enough disclosures. Just so you know, keep your energy in check. Be respectful of each other. Minimize your words, please. Let's get into this. So I am going to share my screen. One moment. Okay, Darren.
Okay, so yeah, we can actually just start rolling right into this. This is a direct message, or this is a direct.
Well, actually, forgive me. Let's just go back. This is the actual letter, and forgive us. Our friend sent a picture. It was a little blurry, and with the time zone, we were not able to get a kind of a clear one. But this is the actual letter that your friend used. And we have upgraded it since then, but let's go through the old school ones.
Yeah, okay. I haven't even looked at the date on this one. Okay, this one's 4 years old, right? So this is actually going back a ways, but you'll notice, number one, we have made an incredible amount of progress in 4 years, but I'm just going to start reading this, and we're just going to start breaking this down as we go. Okay, so number one, special notice. Every time we send notice is a very blank term. What kind of notice? Is it a general notice? Is it a special notice? Is it a notice to what? What is it? There's all types of things we can attach to the word notice. When you send just word, hey notice, let's take that opportunity to be a little bit more precise. And even back then, 4 years ago, special notice, even that, I would embellish on that a little bit today. I would even, increase that thing's power. But anyway, we're addressing this thing to the Deputy Attorney General of Canada. Your country, whatever, all these deputy attorney generals that are all working in the same capacity. And here's what they're doing. I've mentioned this in the past. The deputies are the ones that truly hold, let's call it the real power. They're the figures that are in the background hiding. They have usually lifetime appointments where they're in this office for, 5, 10, 15, 20 years. They're not the government agents that keep coming and going every 4 years with an election. These cats are a little bit different. They hold a lot more power than people would give them credit for. So with respect to the Court of Queen's Bench, and again, this will determine every other country, but the Queen's Bench is a jurisdiction that is capable of hearing chancery claims or equity claims. They are, depending on what we bring to them to hear it. And again, this is where we've ran into a lot of problems. How do we get our equitable claims past the clerk? That has been the hardest part, to get to chamber so that the judge will even hear what it is you're talking about. It's taken us years to even get that far, because the clerks look at your stuff and bounce it instantly. Well, Meads versus Meads. This is vexatious and just not clean, as they want to call it that. So it's taken us a while to get around that. But anyway, the Court of Queen's bench is capable of hearing equity. We just got to bring it properly. The following shall serve as special notice. Okay, moving on. I, Robert Grantee. Now, that right there is establishing power of appointment. It's establishing power of titles, and it's establishing who has something right now, because in equity, titles mean a lot. Now, you have to have the thing in order to get rid of it, as I've mentioned in other videos now. So the grantee is the primary position. The grantee is the one that holds both titles. Remember, equitable title and legal title in the same person, the same individual. Once he makes a claim, or once he expresses it, or once he vocalizes it, that, hey, I got both of these things, and now I'm going to do something with them. Bringing them together is what allows us to get rid of one of them. And here how it kind of works. The operation of the doctrine of merger does not happen through the rules at law only. What that's saying is, if you're going to be dealing in merger, you got to be bringing an equitable claim with a legal claim. Because you're in possession of that birth certificate and the legal interest in it already, that's already been established. There's already lots of records indicating that. So, okay, that means we're presumed to already have the legal title. That's why we're eating all the liability all the time. Now we want to come forward and smash a superior interest right into that thing. Here comes equity. Boom. They merged for just a moment in time. After they merge, one of them, the weaker one, the lesser estate, literally falls off. It literally peels off like a sunburn after a few days. So the grantee position is huge. The private citizen, private national, private individual, private, that as well is indicating, not for public consumption. Again, this is very important. We're starting to establish, we're starting to partition, we're starting to divide, we're starting to separate interests. Super important as we go here. So this gentleman goes on to say that he's exhausted a lot of his administrative remedies at law regarding the adversarial possession of his property, currently under the control of the public trustees and the Minister of Health. That minister can change. Again, this particular guy, he had a beef with the health industry, so he was really trying to home and focus his attention in on that. That doesn't have to be the health minister. That could be the attorney general acting as the minister of justice. There's flexibility with who we direct these notices to. So he's claiming that he's going to be seeking equity and doing equity. Again, the court will never presume that you're seeking equity unless you can prove you're actually capable of doing equity. That's the thing. If we don't prove we're doing the equity, if we can't prove we're coming with clean hands, the judges and the clerks won't entertain our process. So moving on. Here we go. He's suggesting that he's already sent notice of acceptance. Notice of acceptance is a big deal, because what's going on here on a few levels. We got two trusts on the fly. Really, we have two situations that we can start to get involved with here. We got the creator that was bestowed us a gift, an inheritance, a birthright through scripture, through the Bible. That's one thing going on here. And then we got the whole legal thing going on that skewed the first thing. So we have two elements that we got to be addressing here, kind of juggling two things at the same time. The concept of basically saying that I accept a covenant or a contract or a situation, that puts you into a position of playing. You're actually able to now move forward. You got to accept something in order to deal with it. If you don't accept something, how is a judge going to put you in a position of being able to negotiate it? And again, I'm not the first one to touch on the acceptance concept. This is a big one. This one goes back a long time. So, for example, you may want to be suggesting, I accept the fact that my parents on such and such a date did this, then failed to do that, et cetera, et cetera, et cetera. As a consequence, or as subsequent to these events, I have taken it upon myself to do the following. And now this claim will unfold. We've had paperwork sent back to us by the court system saying, your claim needs a little bit of work. Tighten this thing up. Give it to us more strategically. Give this thing to us more, more precisely. They don't want opinions. They don't want your feelings. They don't want emotions. They want hard material facts. Actually establishing that is a little bit harder than you think. Go on Black's Law, start looking at what is, material information, what is material subject matter, and you want to know what the answers, you want to know what the definitions are. It's pretty ambiguous. It doesn't really ever even tell you what the material substantive nature of your claim is or what it should be. Now, this is where going back and maybe doing a little bit of research, looking at how other cases have been styled. You can see in a claimant's opening argument, oh, this is how they styled their proceeding. Okay, beautiful. I have working examples that have gotten us into chambers, so we're going to clarify some of that as we move along here. But again, today's presentation, it was just to regard these two letters that has enabled this good friend of ours to have been pulled over twice now by the police. And as soon as they look at his license, they say, have a nice day. This same gentleman also this is the guy who got the letter in the mail about 2 years ago now, a year and a half ago, from the driver's license people saying that, oh, your driver's abstract is clear. Same guy. This guy sent one of these letters, same two letters. So to get, if my friend here had sent a letter to the Department of Motor Vehicles saying, hey, give me an abstract update, okay, now they would have responded to him. No, he didn't actually send a request at all. They sent it to him automatically. Something's going on here. They just don't do that for no reason. Here, look at your driver's abstract. It is clear. It's clean. I was with that gentleman in a car when we were teenagers, when he got pulled over for speeding or stop signs or whatever the problems were that we were involved with back in the day. I know for a fact, because I've been with him firsthand, that I know. And he has also suggested, yeah, he had a lot of stuff on his abstract. So what event has caused his abstract all of a sudden get cleared? Now, again, this isn't a big deal in the overall picture, but it's evidence of little successes. Our big successes come when we experience a whole bunch of little ones. We got to start this process somewhere. Moving on with the process. So he has sent a notice of acceptance and non-disclaimer. Non-disclaimer is going to be setting the stage to a few things going on here. Number one, this is where we're actually going to roll in one of these new documents to come. The notice of quitclaim deed. This is an important deed that we're suggesting that gets completed here. It's really short. It's not a big deal. You can literally just attach it to a court file. You can go get this recorded through the registrar of deeds, et cetera, et cetera, et cetera. This deed, this quitclaim deed, is essentially saying this: I quit claiming to be liable for this entity. In a nutshell, that's all it's actually stating. It gets embellished a little bit more than that, of course, because you got to describe certain other things. However, I quit claiming to do something. Well, if I quit claiming to do something, then that opens the door for me to be doing something else. And that's what some of these other documents are going to put into position in place for us. So he goes on to say that there's been no response to anything that he has sent forward, which is pretty typical. Again, another fantastic colleague of ours in the United States has really, really proved this throughout. When they do not respond to your stuff, do not take that as a bad sign. Regard that as equity is in keeping with running with silent doctrines. So when silence is before us, just keep in mind, okay, that means this is working. If there was a problem with it, trust us, they get back to you real quick. We don't like this, get rid of that, that's vexatious, go below, whatever their responses are going to be. We can't deal with this, we can't deal with that, yada, 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 yada. But when they don't respond, that is your indication that, hey, things are going pretty good, keep going. And it's only through your failure or lack of ability to proceed is what literally defeats our entire purpose here. So he's suggesting, okay, we've got some silence, maybe 30 days went by, and now I'm going to give you notice that, hey, you had an opportunity to get involved here and you didn't. So he's suggesting that equitable doctrines are running. Okay, this is fantastic. Every time that you mention the word trust, every time that you mention the word equity, every time you mention the word devisee, every time you mention the word legatee, sedicate trust, all these types of things are helping to build your intent. We've had the judges coming to us and say, okay, well, this is great. What do you intend to do? How do you wish to proceed? That was a big one. Right in the middle of one of our hearings, the judge says to us, okay, that's great. How do you wish to proceed? It's like, right? So we need to be prepared to answer that properly. He goes on to say, he's got an equitable, he will be filing an emergency litigation order to the courts. This, he puts a date, as his equitable interest in subsequent property is in peril. Fantastic. He's establishing that, hey, there needs to be redress brought to a situation here. for a specific purpose, because there's certain confusions and he wants to avoid trespasses. He wants to avoid harm being done to certain parties, things of this nature. So he goes on under a certain section here where a rule of equity conflicts with the rule of the common law. The rule of equity prevails. Now, each and every one of us can literally go into your areas, rules of court rules of civil procedure. Every court in this world will have one clause minimum that talks about equity rules shall prevail. Again, I've talked about this many times on other videos. Why is that? Well, this comes from the Judicature Acts out of England, 1873 to 1875. This merged courts of chancery and courts of common law into one court. You know, at the end of the day, they were like, why do we have two courts, two judges, two complete processes? This is a big freaking waste of time. Let's just smash these two things together and leave it up to the judge to exercise his discretion based on the evidences and the claims brought before him to decide how to proceed. This is why when we send, again, in the beginning of this video, when I'm suggesting don't leave your notice naked. Well, here's another one. Take judicial notice. Ooh, that's a meaty one. When you start talking about judicial notice to a judge, he is being invoked. He's being encouraged. He's being compelled. You're forcing him to acknowledge something. Otherwise, he has to disclaim it. And his silence actually means that he's accepting what you're doing. Again, and that's something else we've experienced in our court process here, where there may have been a little bit of a misunderstanding, or the judge asked us a question. Boom, you provide one quick, simple answer. You relate it to a maxim, add a little bit of substance to it, and the judge moved on. The Crown didn't say a peep. The judge asked us 3 or 4 questions, literally in a row, and we just swiped them. Boom, 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 boom. This is where having a little bit of knowledge comes into play. Just because we're providing you the templates here, really is all that we're doing. You still got to have a little bit of knowledge so that when the judge asks you, are you going to say, hold on, judge, just a moment, please, I got to call Darren and see what the answer is. They're not going to be thrilled if you start talking like that. Again, I can help us, and with the love and the contribution and things from others, we can all start working together to get us there. This has come to a point in time where we all, again, I've put a lot of effort into all this, and I do not mind putting information, putting things into your possession so that you have some tools to start moving forward and doing something for yourselves. Because I know how frustrating this is, feeling like, oh my God, my entire future is in these people's hands or that group's hands because they seem to have more information than I do, and they're not feeding me as fast as I want it, and I'm starting to feel frustrated. When you start to feel frustrated, sometimes a lot of panic will set in, a lot of fear will set in, especially if you're one of the ones that has a court case on Monday, right? I know how you feel right now. Trust me, Dean and I have been there a number of times. That is nothing new. I can relate to that, which is why I'm doing what I'm doing today. I have no problem spending an hour. And again, I would love to see that hour grow. An hour here and an hour there, maybe whatever it takes per day. This is something that I really feel that needs to start happening. So he's suggested here that he's got an attached affidavit to this. That's pretty important because under the court rules, we can't really enter any evidence unless it's attached to an affidavit. Simple. Okay, yeah, it kind of makes sense. Now it'll get down to, okay, do I really need to get my stuff sworn in front of a notary or in front of a commissioner? If you know how to play it a little bit and you can present yourself, if you can not identify as the thing, prove that you're just in possession of this thing to act perhaps, for the interest of a trust. If you ask the notary to act in his or her private capacity, has anybody ever asked a lawyer to act in their private capacity? That's actually a thing. I've seen it. I've actually seen, my brother and I have both done this. We actually go to the notary and say, okay, and for your letterhead, make sure that you are a notary or a commissioner under the Dominion of Canada. They're like, oh yeah, okay, no problem. They instantly knew what we were talking about. The Dominion of Canada was a different entity than, for example, than the federal government that we all see today. Now, every other country is going to have something similar that has happened around 1933 or 1914 or whatever, again, under those rules of emergency banking relief, et cetera, et cetera. We all have the opportunity to revert to what the old systems were. Again, land titles will evidence this. They have an old system and a new system. The new system is the Torrens system. The old system is all the equity one, based on titles and estates, not you acting as a legal fiction with incapacitated rights. Literally, you're renting. You're never an owner when we have that legal liability. Again, heirs do not hold property rights. So moving forward, the box around the squiggle here and his title, without prejudice, without recourse. Yeah, that's pretty good. I mean, you know, a lot of people put all rights reserved. Okay, you know what? Instead of saying all rights reserved, we can start to, you know, nail that down a little bit more, but especially when we're trying to get rid of the legal rights. Okay, so let's pretend that all of the above information in this gentleman's letter here, he has suggested that he wants to get rid of the legal rights, okay, and be left with the equitable stuff. So now right at the end here, he says reserving all rights. So what did he kind of just imply there for a moment? Does it kind of feel like he just took all that legal stuff right back again and he's holding that? Again, there's two parties, well, three technically, but two. One's to have and one's to hold. Again, there's a lot of marriage type union language going on in the background. So we grant one title for that party to have and to hold, or to have. And then I'm going to grant myself this title so that I hold this one, or I have this one. But it's creating a stage where the two parties have duties respective to two different titles. They do not commingle. They are not one and the same, and they are completely enforceable. That's the way this is going to roll. It's actually a little bit more simple than we think. So again, developing the affidavit that he mentions here, okay, that's going to be another presentation that maybe I do in day 4 from today. It doesn't matter. We'll worry about that then. So this document, again, it lays a lot of substance down. Could this be improved? Of course, loved ones. This is 4 years old. To think for a moment that we haven't made a little bit of progress in 4 years would be rather insulting. So let's just presume that, hey, this is actually pretty good for 4 years ago, because between this one and the next one I'm about to show you, something for this gentleman has started to work. So I hope y'all kind of got a little bit of a screenshot of that. If you want, I think I can go back to it for a moment at the end here. But at this point, I'd really like to just switch to the next document. What we're going to do here is, so let's suggest, for example, we have this meeting again tomorrow. If people have questions about this letter, because now it's going to be, okay, you showed us the letter, how would you improve it, right? Clearly, that's going to be your next question. We will get into that one tomorrow, because we'll spend a little bit of time developing and improving these things. So here's the second one. This one was pulled right out of a court case that the same gentleman had used to bring his claim, his interest, things of this nature into a court case. This gentleman actually was in the throes. His mother was put against her will virtually into an old folks home by our friend's older sister, and our gentleman friend here struggled for 2 years to try to have that situation reversed. So there's going to be a little bit of language in here where it's talking about his mom and the health things again. But again, this situation is going to be flexible for each and every one of us. Whether you're a little bit upset that your neighbor's running around with your lawnmower, whether you want to be helping to get your mother or your grandfather out of an old folks home or get out of a speeding ticket, whatever the case is, we are going to be using a lot of similar language here. We're just going to be starting to, drop it into different segments, and we're going to start to, direct it in a little bit better fashion. So, okay, so right up here, we got the RN number. Everyone wants to know, okay, well, what's the RN number? This is just the registered mail sticker number that he uses to send his registered mail. You can literally capture an interest in that specific number. We can start talking about that in the future. I know I've touched on it a little bit in the past, but again, so this letter, this is going back this one you're looking at is almost 2 years ago. This is the one I was referring to when I said it's about 1.5 years-ish old. So he goes on to say, okay, so to Her Majesty and others, again, et al. That just means and others. So that's casting a wide net. Who are you directing this notice to? Well, the Crown and all its agents is literally what he's saying right here. So he's saying that this guy coming forward as the president and named personal representative holding the office of, stick something there in the title. Do you want to be the administrator? Do you want to be the executor? Do you want to be the beneficiary? Do you want to be the grantor? Do you pick your position of his family trust? This office has been assigned and holds all entitlements and lien interest to securities held in trust by Canada or your country for the grantor beneficiaries of the following parties. So that's a bit of a mouthful, but there's a lot of substance getting laid down right there. Now, again, as I just alluded to, would I improve that? Absolutely. We'll talk about that. So he just identifies the parties here. The only thing I'm a little bit hesitant with is in his opening sentence here when he says that he is the president of a certain something something. From all the digging and all the research I've done, I've never really seen the word president and trusts in the same context. So to me, again, 2 years ago, this could probably be construed as a little bit of a commingle right here. I would be hesitant to use the word president right here. I would rather use something else. There's a variety of other terms: the trustor, the settlor, the grantor, the legatee, the devisee, the life estate interest holder. There's a whole whack of other stuff that I would rather use than president. So let's just kind of overlook that one. Moving on. He's talking about an assumed association to the secured parties by any offices of Her Majesty the Queen has now been expressly revoked. Okay, so he's suggesting that there's been a change of interests of the parties. That's what he's actually trying to say there. So you could actually paraphrase this and tighten this up a little bit. Your Honor, there's a confusion of title, and I know that the court of itself will never presume a party to have a better title or a better claim to equity than that which he discloses in his pleadings. What that's saying is the court doesn't know you're about to do equity. The court doesn't know you have a claim to a better title. The court doesn't know what the hell you're trying to do. So it's important that we outline this, rather concisely, rather precisely, in order to avoid wasting court time, yada, yada, yada. We don't need 40 pages to express this, like Dean and I and some other, gifted ones in the past thought we had to do. Again, this letter is also 1 page long. So we've definitely made some progress with streamlining and condensing our pleadings. Okay, so he's talking about the family trust here. This is all pretty good because, as a matter of fact, I took some photos, some screenshots of something that I was going through Black's Law, I don't know, about 2 weeks, maybe not even 10 days ago-ish. I was looking under, some estate stuff and, inheritance stuff and trust stuff. And, I spent the better part of a third of a day just doing some digging. And Black's Law Online, as you're keying in your words and your searches, it has another group or another category off to the right-hand side of the screen where it kind of says related searchable things or things that are kind of talking about what you're doing. And for some reason, as I'm keying in some of these specific wordings and phraseologies and things in the other, guess what pops up on the right-hand side of the screen when I'm talking about trust law? I shit you not. It literally said Clifford's Trust. And I'm thinking, I haven't even typed in Clifford's Trust. So why would Black's Law Dictionary be inserting my former surname into a related searchable item? And I'll post that picture here later on. I don't know, maybe you try it. Start Googling some stuff with Blacks. See if your surname pops in there. Like, is that a ghost insert? Was that random? I'm going to suggest no. That's someone else on the other side, whether it's AI or, one of the fact checkers, whatever you want to call them. Someone's sitting on the other side of the screen watching what we're doing. Seems kind of logical to me. I've had other instances in the past where things like this have happened. So I'm a pretty firm believer in they are actually doing as much as they can to help us get to the land of safety, get out of the purgatory that we've voluntarily put ourselves all into. There's a lot more good helping us in the background than we could ever imagine if we only knew. Again, when I hear people say, oh, the system's nothing but corruption and you'll never get anywhere and blah, 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 I call, do a little bit more work, do a little bit more digging, try a little bit harder, because I used to think like that 10-ish years ago until we started to see some favorable results. As soon as you start seeing favorable results, how can you now start claiming that there's corruption back there? And again, I beat a few criminal charges back in the day without a lawyer while I was in jail. And just some basic stuff went down and I got released instantly. And the matter was dealt with. So again, having experienced that firsthand, it's going to be hard for someone to tell me, oh, the system's just corrupt when I was looking at a 5+ year federal sentence. Beat it like that. Okay, well, I walked out of there unscathed. I was pretty happy. I was, pretty elated. Continuing. So he goes on to say that, by security agreements, this is very important. Again, this one was 2 years ago. We were talking about the security agreements. Back then, I didn't have the knowledge I do today, of course. Back then, the gentleman that was helping with this document didn't have a clue what security agreements were. This is the point of doing the work, doing the due diligence, and not giving up. Really important. We're going to hear it. We're going to start to explain some of this stuff. As a matter of fact, another loved one this morning, Michael John and Trust on Facebook, was posting things about our minor accounts have never been claimed by anybody with privity to it over the age of majority. You have to be over the age of majority to prove you're not an infant to start with, and that you have to be laying your claim properly to your minor account, which is attached to the custodian account. And another word for all this is your securities account. Again, as I've mentioned in the past, you have a securities account first. Once that account is established, now they can issue a certificate from it. The certificate never appears or materializes first. The account, the account number had to be assigned to a particular entity. A particular event had to happen, which caused a registration. That registration event is what we can lay claim to later. Again, I was responding to someone a little bit earlier today where I've alluded to, mom and dad kind of dropped the ball at the birthing event. They had 7 years to basically kind of express an interest in an event after registration. You create the thing, and then after the event is registered, now you got to come in and express an interest in what you created. And a few people online are still giving me flack about, it's not mom and dad's fault, blah, 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 blah. So, okay, well, the facts are that an abandoned event has happened. This is where the escheated estate comes from. The escheated estate rolls into an abandoned interest. All mom and dad had to do was say, hey, Your Honor, I have a particular claim respecting this. I'm not sure what's going on, but here's my question to the court. The court will always entertain questions. That's one of their primary duties. But you got to phrase your question right. You got to send it to the clerk properly. You gotta do some stuff. So moving on, he's talking about declarations, another good one. Proclamations. Okay, we're talking some pretty similar things. It's just, they're slightly different. And he's talking about power of attorney. Power of attorney, I'm going to throw it out there at this point. Yeah, we used to think that did a lot back in the day, but I'm going to suggest that we kind of have the power of attorney right now as an infant, but when we start to try to express it, it kind of seems to get taken away from us. As a matter of fact, the same gentleman that wrote this letter had his power of attorney taken away by his mother's doctor because Buddy here started talking about some equity stuff. So the doctor literally pulled his power of attorney like that. Two problems. One, he didn't register or he didn't protect his power of attorney. He didn't kind of create an enduring power of attorney. He didn't file an interest. He didn't file his power of attorney at land titles. So it was kind of floating around. It was vulnerable to attack. And the doctor could literally just come in and take it away. So here's the evidence. Is it really yours if a doctor can just swoop in and take it from you? Clearly, it wasn't really yours. So moving on. To be clear, it is the parties relating to the certificate lien interest that I am noticing your offices and not the parties of the Social Security account number. Okay, he's making some distinctions here. He's talking about lien interest. He's talking about notices. Is it wise to make that statement at this point? I'm going to suggest that it's okay. He's talking about there's another account here hiding in the background that may be subject to some of the things that I'm trying to lay down here, some of the interests I'm expressing, some of the liens I've been talking about. And again, where does that word lien come from? Well, we are not supposed to be restrained from our alienability, however you want to say it. What is alienability talking about? It's talking about your ability to say, whoa, I don't want to be associated to that thing. I'm a foreigner to that thing. I'm of a different jurisdiction. I'm an alien to that interest. So could that be expanded upon? Of course. Would I tweak that sentence? Yeah, of course. Moving forward. Due to the health condition, the currently of his mom, who is named as the beneficiary of her security number, he's talking about her being forcibly confined, those offices, This is where you can actually start to talk about your particular situation that you're seeking relief from. I've been wronged. There's a grievance here. I have a conflict in variance with the rules at law. Something has happened. I'm here to correct the events. I'm here to set the record straight. Think of us all as having a a cloudy record. Our record went whoop, and went right out to right field because it was abandoned. It was neglected. Nobody loved the interest. That's why the state swoops in and takes it and manages it and administrates it for us on our behalf. Again, I've mentioned some of these other things and other loved ones in the past. So he goes on to say, that he's assigning certain things, or there's titles moving around in the background. He's suggesting that the trustees, those offices involved, are acting on stolen authority and association not assigned to them. I'm going to take this opportunity to definitely correct that wording, because I don't believe that that's quite the case. I do believe that they are acting on the proper authority. And by association, they're actually doing the jobs. That title was assigned to them by default. The Attorney General's office can literally swoop in without further inquiry, which means he doesn't have to have a suit before the Court of Queen's Bench, or whichever court is, in your neck of the woods. The Attorney General's office doesn't have to instigate a legal action to take that legal interest because it's just sitting there. Otherwise, what would happen if the Attorney General had a lawsuit to do that? Isn't there going to be a record of it? We actually had a part response to some of these evidences, these letters, that the Attorney General has suggested, whoa. There's no evidence. There's no evidence of the event of an escheated estate actually taking place. And we thought, that's interesting. So here, this is what's going to lay fundamental credence to that point. We got to claim that event happened. If you don't come forth and say, hey, this happened way back in the day, what does their record show? Their record actually shows 0. There's been no activity with this account. This minor's account is still unclaimed. And again, thank you, Michael John, for that. I've seen similar things to that definition in the past. And again, I've been talking about the securities and security agreements here for there you go. You can see it from 4 years ago. So there is a point to the securities. The securities, yes, although they're legal in nature, they also carry an equitable character attached to it. That's the unwritten part. That's the part that is, it's undisclosed, or it's unclaimed. It doesn't exist until you say it does. So he's talking about, that they're ignoring his delegated authority and the personal representative and the president of the family trust. Okay, he's kind of just saying, hey, you're not really doing what you're supposed to be doing, and despite my equitable intent, I expect more. So he's trying to build a bit of a case where there's some problems here, Your Honor. There needs to be a little bit of a redressing going on. That's all part of building our case. Moving on. Unless you or anyone within your organization can override or provide a superior priority claim. Well, okay, so we're kind of getting into a situation here where we're saying, hey, unless you can provide a priority claim, but here's the rotten part of that statement. They kind of do have a priority claim because we helped create it when we applied for that social contract when we were about 16. That signature on that social contract granted them priority, granted them power or authority over us. We literally volunteered to serve the state right there. So to make that claim at this point, I would definitely like to tweak that one. So again, he goes on to say, he requires all parties involved within your organization to be notified to cease and desist within 14 days of receiving this notice, and to restore all authority to the named personal representative of the offices of the such and such trust. Here's the problem with that statement. Yeah, personal representatives are great, but you know what? You kind of don't have one until the court appoints one for you. We can claim one's there, but what happens when the judge says, well, where's your personal representative? Who is it? Well, I don't have one. So it would have been better to say, hey, Your Honor, hey, court of competent jurisdiction, my trust is found wanting of an executor, of an administrator, of a trustee, of a personal representative. I've talked about these things in the past. Show up to the court or show up to the magistrate or show up to the authority and say, hey, there's a problem with what I'm trying to do and I need your assistance to help fill in some gaps. The trust is found wanting. As a matter of fact, that is a very, very loaded statement. It compels the judge to act on his judicial discretion, to look at the material that you're furnishing before the court. You're actually compelling him, you're invoking his judicial discretion, his authority to say, hey, is there worthy trust claims here? Have securities that have been perfected? Again, keep in mind here, back in the day, loved ones, we weren't doing a lot of perfecting of some of these things back here. This is 2, 3, 4 years ago. I've only kind of really stumbled into the perfection processes here. I'm going to say in the last year and a half to 2 years. That is an incredibly important part. Equity will not perfect an imperfect gift. Again, this is a maxim. We have to do the perfecting. That thing will not perfect itself on its own. If it had, the escheated estate would never have happened. Mom and dad, grandpa, grandma, an aunt and uncle, a best friend, the man who delivers your mail could have actually brought forth a claim on your behalf or your interest if he could prove any type of relationship to you. It didn't have to be mom and dad. Anybody with an interest. Well, I'm interested in my best friend Bob's here situation because he's incapacitated. He doesn't know how to do that. But Your Honor, I would love to set up a private trust for this guy where his education, his medical well-being, and his social competency is improved. And the judge will literally roll into your private minor's security account, take out X amount of funding, appropriate it to another account, and then you would actually have access to those funds. We could have all had access to these funds from the very beginning had somebody done something, said, hey, Your Honor, we're not interested in the public system, so therefore you can't just leave us hanging. And because I've done certain things to this security or with a deed of trust or with a deed of acceptance or with a notice of interest or a statement of interest or affidavits and schedules and all these things, all these mechanisms or mechanics that are bringing information to your attention, Your Honor, it is necessary, it is prudent, and it is expedient that the claimant have the relief that they pray for. So, in a nutshell, back here in the day, we had a fair bit of success with just simple correspondences like this. Again, we've made a lot of progress. There's a lot of stuff that we're going to change, and we're going to get into that. I'm suggesting starting tomorrow. Tomorrow, if any of you have direct questions that we can start to correlate to these particular letters, yeah, let's spend half of tomorrow's 1 hour talking about this a little bit. And again, although everyone's muted here right now, there's going to come a point where, we start to unmute people and we're going to try to coordinate. The queens are going to, okay, whoever puts up their hand and has the I got a question. We're going to deal with that here pretty soon because as a matter of fact, we got 7 minutes, I think, until this thing automatically goes swipe. I'll be in the mid-sentence and this screen is going to go black. Don't worry. The point here, loved ones, I'm going to be back tomorrow. I don't care what's happening to me and our movement, our group, whatever you want to call it, online. That is of no recourse. That is of no concern to me. I don't care what people are throwing at us. The objective here is to give you as much as I can today, tomorrow, and the next day. You're actually going to find, okay, even though these people take this on the chin every day, they're still doing something that I'm very interested in because I've been following this stuff for a number of years, or I've maybe only been following it. I only heard about this stuff a week ago. Doesn't matter. But when I started to look into it, when I went to Black's Law Dictionary and I actually looked up, inheritance and escheated estate, and all the types of equitable interests that can be. Okay, when I use the word trust, you want to know how many different kinds of trusts there are? Oh my God, lots. There's lots of conditions. There's lots of precepts and intents that can be created around a trust. Here's the difference between a trust and a corporation. So again, I got, loved one here suggesting that he's trying to create a trust and then he's trying to claim to be a president of it. Here's the difference. Presidents and corporations really go well to, each other. Trusts and presidents, not so much, because the trust is actually a non-registerable event. You can record it, you can file it, you can lodge it, but you can't register it. And if you don't believe me, I'll provide some of the legislation from the Land Titles Act in any of the provinces here in Manitoba that actually restricts the registrar's ability to register a trust. Why? Because as soon as you register a trust, the contents of the private trust now become public. So doesn't it sound like we kind of just defeated the entire purpose of creating a trust if we're just going to go disclose all of its contents to the public? So again, a little bit of confusion here, a little bit of commingling. A judge is going to pick up on that right away. A magistrate is going to pick up on that right away. And here's the other cool thing. Once we start to bring our paperwork, the clerk at the front counter can deal with this stuff. I've seen this actually in the legislation. You don't have to bring it to a judge. It only goes to a judge for a final approval. And this is kind of how the process goes. You bring it to a master. A master creates a report. That report goes to a judge. The judge approves it, sends it back to the masters for the master to deal with it. The judge has got better things to do. These applications, these claims, believe it or not, loved ones, are so simple once we get this nailed down properly that just a clerk at the front counter can issue process, book a hearing, deal with your paperwork when you bring it properly. Tomorrow, we're going to start talking about how do we bring it properly. Styling of the proceeding and the opening caption or the opening clause is kind of tricky. It took us a little while to navigate that. We've had a lot of court stuff bounced out of court saying, no, your motion, your application, your petition is, we can't work with it because it's deficient. But they don't tell you where the deficiencies are. Again, so trial and error, trial and error, trial and error. This gentleman here that you're looking at that was using these documents a number of years ago, I believe he went to court 7 times or seven different applications where his first case, after a few tries, the judge finally bounced it. Second try, a number of applications, the judge finally bounces it. They will literally remove or scrub or dismiss or not even stay, but they'll withdraw. They will strike our claims unless they're made properly. So again, a lot of information had to be downloaded to us through a lot of trial and error to finally get those captions dialed in. And we've got them dialed in now, like to the point where in our case that we're dealing with, for example, Jody and Kim here, the judge halfway through one of the hearings, interrupted the Crown when the Crown was trying to rebut our claim. Our initial paperwork was deficient when we named who we were or what our capacity was. Halfway through the trial, without even amending the written version of our stuff, we just started saying, Your Honor, no, Lïve's error, Nadeau's error, Nadeau's error, error. As soon as we started to say that, believe it or not, the Crown was still trying to refer to us as the all caps name or the first name, the given name, and the surname. And the judge literally cut the Crown off mid-sentence and said, from here on, from this point forward, refer to the petitioners as Lïve's error, Nadeau's error. So he literally corrected the record, stopped the Crown from continuing addressing us under that old title, just by us speaking it. That's the judge taking notice of our equitable position, and he's literally compelled to take judicial notice of equitable estates and equitable pleadings when they are brought or when they arise. Very, very important. So unless we start pleading some of these equities, unless we start talking about some of these things, unless we start disclosing better titles and better claims to equity, the judge is not bound to help us. So it's very important that we start dealing with those things off the top. Okay, so we got 1 minute here. I know we're going to run out of time. I'm not even going to get to questions here, but you know what? Again, tomorrow, that's what tomorrow's for. Same time, same place. Let's just roll with that. We're going to continue with that. And have some questions ready, as the queens have suggested here in our earlier post. Start to type your questions in the chat. We're going to go over your questions tonight, and this is where, again, all the legwork going on in the background, it doesn't stop for us. We keep continuing. I keep continuing to show up, and I'm going to start to share everything to the best of my abilities. I think that's appropriate at this time. I've alluded to doing it in the past, so now you're going to be witnessing it firsthand. Okay, loved ones. So again, I might lose you here any second. So
hello. So thank you, Darren, for showing up for that. The whole point of this was Darren promised something online, and we are very big on follow through. And so that's why we wanted to do this and not only follow through, now he's taking this to a whole other level. So again, there's going to be more things to come. We will keep the chat open and the line open for a little bit. So if you have any questions that came up, you can put them in the chat so that we can compile them. And first thing, as soon as we start for tomorrow, we'll address some of those questions and we'll get that addressed for you. So thank you so much, loved ones, for showing up, and we will see you tomorrow.
Thanks,
Take
everyone.
care.
Take
Bye-bye
care.
now.
Love you.